Hello students and welcome to the lecture. So students, as we know that we had started the public interest litigation in the previous lecture, okay? And we had discussed several facts and figures about it, okay? And these are the topics that we have scheduled for the discussion under this particular heading, like the introduction part, thereafter the meaning of PIL, thereafter the features of PIL, thereafter the scope of PIL, thereafter the principles of PIL, and then comes the guidelines for admitting the PIL. Okay, these are the things. And basically, we had discussed the facts and figures in the previous lecture. Like I had told you, basically, the USA was the place where it was originated and developed. And we had discussed that the judicial review, judicial activism, and the public interest litigation. All of these three things basically we had adopted from the USA. Okay. And we had discussed that basically the public interest litigation, or PIL in short, is the born child of judicial activism. Okay. And we had discussed that the judicial review is basically empowered by constitution itself. Okay. But the judicial activism and public interest litigation is basically an extended part of judicial review. It is an extended part of judicial review. That is what we have discussed. Okay. So basically, I hope that you have revised the previous lecture in the well enough manner. Before you have come for this lecture, as many times I have told you, that is for your own benefit. So if you are doing this on the regular basis, the thing will be beneficial for you. And if you are not doing this on the regular basis, the thing might be difficult for you when you will have to face your examination. Okay. So let's start from where we had left in the previous lecture. Okay. So after finishing the introduction part, we had to start the meaning of PIL. Okay. So the introduction of PIL in India was facilitated by the relaxation of the traditional rule of locus standi. Okay. But from going, you can say before going forward, let me ask you one simple question. Like, who were the pioneers of PIL in India? Who were the pioneers of PIL in India? You are required to tell me the name of them, okay, and the full name. All right. So you have 30 seconds to think about it. Then I will give you the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The times. So the correct answer is Justice P.N. Bhagwati. Another one was Justice V.R. Krishna. Okay. So these were the pioneers of PIL in India, and basically it was introduced in mid 1980s. Okay, that's the thing. So basically it is facilitated by the relaxation of the traditional rule locus standi. According to this rule, only that person whose rights are infringed alone can move the court for the remedies, whereas the PIL is an exception to this traditional rule. So basically we could say, suppose if we go by the rules of traditional judiciary. Okay, so it means that suppose this is the code, okay, and these are the two persons here, or these may be the group. So the crime committed, or you can say the act committed with him, he was deprived of some rights, okay, and that one is okay. There is nothing happened with him. So basically, the traditional judiciary, or you can say the concept of locus standi states that the person with whom the thing committed is the person who could go to the court. It means that only that person is allowed to visit the court and this person is not allowed to visit the courts. Okay, that's the thing. But we had discussed that basically due to the unrepresented, that these were unrepresented in the judicial and you can say the legal services and they are not so capable to take care of it. Okay, so that's the thing. Okay, under the PIL, any public spirited citizen or a social organization can move to the court for the enforcement of the rights of any person or group of person who, because of their poverty or ignorance, is socially or economically disadvantaged position are themselves unable to approach the court for the remedies. Like we had discussed when we talk about the 1960, the time when it was originated and developed in the United States of America. So the main cause behind it, behind the development of this concept was the failure of legal services provided to the unrepresented and underprivileged communities and the section of people and the individuals to whom the true justice was not made. Okay, and if we go by the locus standi, so what we have discussed, that basically only those persons with whom the thing committed, then only they could move. Okay, so that's why the persons who were not able, they were unrepresented in the sphere of judiciary and were, you can say, exempted from the judicial remedies. Okay, that was the thing. So here the same thing written down here, like the persons or any group of persons who, because of their poverty or ignorance or the social or economically disadvantaged positions, are themselves unable to approach the court for the remedies on behalf of them, any public spirited citizen or any social organization which might be or might be not the victim of the thing committed, okay, they could move to the court so that the court could hear the proceedings regarding those who could not come to the court because of these reasons. Thus, in a PIL, any member of a public having sufficient interest, okay, can approach the court for enforcing the rights of other persons and redressal of common grievance. Okay, if we again go by this example, so if we talk about the concept of PIL, then it is not necessary that person should move to the court. On behalf of him, this person could also move to the court, but the case would be regarding that person. Okay, so what it did, it basically accepted the judicial and legal services to underprivileged sections. Expanded the judicial and legal services to the underprivileged sections. Okay, that's the thing. The Supreme Court has defined the PIL as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of community have pecuniary interest or some interest by which their legal rights or liabilities are affected. Okay, it means that basically this is a legal action which has been initiated in the court of law for the enforcement of the public interest or some general interest in which the public or some particular class of community having their adequate interest or some interest by which their legal rights or liabilities are affected. Okay, so then the PIL could be filed. Now here I am going to ask you the another question. The question is, what are the another names of PIL? What are the another names of PIL? Okay, let me give you the hint that there are 4 names regarding the PIL. Now you're required to tell me the names of all. Okay, for this you have the 40 seconds, then I will give you the answer and your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40 the times. So the full form is PIL, SAL, SIL, CAL. Okay. Now, if we talk about the full form of them, first stands for public interest litigation. Thereafter, social action litigation. Thereafter, social interest litigation, and at last, call action litigation. Okay, so these are the 4 names of the PIL, alternate names, and with the definition. Okay, that's a thereafter. If we talk about this, so PIL is absolutely necessary for maintaining the rule of law, furthering the cause of justice, and accelerating the pace of realization of the constitutional objectives. In other words, the real purpose of the PIL are, first is the vindication of the rule of law. It means that ensure that there is a rule of law available for all. Okay. Thereafter, facilitating effective access to justice to the socially and economically weaker section of the society. Okay, it means that those who by themselves could not move to the courts for the judicial remedies, they must be represented by the court by the another one who is representing them. Meaningful realization of the fundamental rights. It means that fundamental rights should not only be enforceable for those who are able to move to the court, but also be applicable to those who are not so able to move to the court. Okay. Thereafter, now after finishing the introduction part and the meaning of PIL, Now we have to talk about the features of the PIL. So the various features of the PIL are explained. Like first is the PIL is a strategic arm of legal aid movement and is intended to bring justice within the reach of poor masses who constitute the low visibility area of humanity. This is what we had, you can say, started in the earlier when we had the talk about the 1960s. Okay, like basically this is an strategically arm of the legal aid movement and basically intended to bring the justice within the reach of poor masses who are having the low visibility area of humanity and generally being ignored by the state and by the people and the upper sections. Thereafter, PIL is totally different kind of litigation from the ordinary litigation. Okay, like which means essentially of an adversary character where there is a dispute between two litigation parties, one making claims seeking relief against the other and that other opposing such claim or assisting such relief. Like if we talk about it, suppose there is any petition filed in the court. So generally the petitions filed for the disputes arriving between two parties generally, and they both are participatory or affected ones of that dispute, right? That is generally happen. Like whenever the petition filed with the court, disputes arriving between two parties and they both are participatory or affected ones of that particular dispute. But when we talk about the PIL, when we talk about the PIL, then basically it is regarding the filing by the person or organization on behalf of others. The petitionary is not necessarily a participatory or affected ones. Okay, so this is the difference. Like the petition is basically disputes arriving between two parties and they both are participatory or affected ones of that dispute. But the PIL is filing by the person or the organization on behalf of others. The petitionary is not necessarily a participatory or the affected one. Okay, that's why it is totally different. Thereafter, PIL is brought before the court not for the purpose of enforcing the rights of one individual against other, as happens in the ordinary litigation, but intended to promote and vindicate the public interest. It means that besides more individualistic, PILs files for cases having common or general interest. Okay, PIL demands that violation of constitutional and legal rights of large numbers of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unaddressed. Why? Because these ones are not so capable to go to the court by themselves. PIL essentially a cooperative effort on the part of petitioner, state or public authority, and the court to secure the observance of the constitutional or legal rights, benefits, and privileges conferred upon the vulnerable sections of the community and to reach the social justice to them. Okay. In PIL, litigation is undertaken for the purpose of redressing the public injury, enforcing public duty, protecting social collective diffuse rights and interests, or vindicating public interest. Here also you could conclude that it is rather than based on individualistic or limited party interest, but emphasize more on public or general or common interest. Okay, that's the thing. In PIL, the role held by the court is more assertive than in traditional actions, creative rather than passive, and it assumes a more positive attitude in determining acts. Okay, so in PIL, courts enjoy a degree of flexibility unknown to the trial of traditional private law litigations. Why? Because whatever the procedure adopted by the court, it must be procedure known to the judicial tenets and characteristics of the judicial proceedings. That's why there is a degree of flexibility. Okay, not a trial of traditional private law litigations. Okay, thereafter, in a PIL, unlike the traditional dispute resolution mechanism, there is no determination on adjudication of the individual rights. That is what we had discussed in the earlier. After this, if we talk about the scope of PIL, okay. So basically, in 1988, the Supreme Court formulated a set of guidelines to be followed for entertaining the letters or petitions received by it as a PIL. Okay, like the PIL was introduced in the mid 1980s. Okay, and in 1983, the Supreme Court basically introduced the first time the set of guidelines. Okay, and this is regarding the entertaining the letters or the petitions received by the Supreme Court as a PIL, like in which manner you could file the letters or the petition, that is all. Okay. So these guidelines were basically later modified in the 1993 and the 2003. According to them, the letters or the petitions falling under the following categories alone will ordinarily be entered as a PIL. It means that not as a traditional method you are required to file the affidavit and all, but if you are following these areas, then only even your letter will be considered as a PIL. So what are these areas? The first is the bonded labor meters. Okay. Thereafter, neglected children. Okay. Thereafter, the non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws except in the individual cases. Like if it is happen with the masses or with the group of laborers. then only your letter will be considered as a PIL. But if it's happened with some individual person, then it is not the PIL, but it is becomes the individual private litigation. So that's the difference. Thereafter, petitions from jails complaining of the harassment, premature release, seeking release after having completed the 14 years in jail, death penalty, transfer, release on a personal bond, speedy trial as a fundamental rights and all. Okay, so these are the matters. Thereafter, the other matters, if we discuss, the petitions against the police for refusing to register a case, harassment by police, and death in a police custody. Thereafter, the petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. Thereafter, the petitions complaining of harassment or torture of villagers by co-villagers or by police from person belonging to the scheduled caste and the scheduled tribes, and the EWS, also known as economically backward section. When we talk about EWS, then it is called as an economically weaker section. Okay, so that's the thing. Petitions pertaining to the environmental pollution, disturbance of ecological balance, drugs, food adulteration, okay, maintenance of heritage and culture, antiques, forest and wildlife, and other matters of public interest. Adulteration here basically talk about the mixture. Okay. Thereafter, the petitions from riot victims and the family pensions. So in this matter, even if you submit your letter, then that will be considered as a PIL. It means that you are not required to go with the legal prescribed standards. If you are filing the case belong to the any of these areas. The cases falling under the following categories will not be entertained as a PIL. Now we have just discussed about that what cases will be entertained as PIL, and now we are going to discuss that which cases will not be entertained as an PIL. First is the landlord and the tenant matters, service matter and those pertaining to the pension and the gratuity, complaints against the central, state government departments and local bodies except those relating to the item numbers 1 to 10 above. It means that the previous one which we had discussed. Admission to medical and other educational institutions will not be considered as an PIL, and petitions for the early hearing of cases pending in High Court and subordinate courts, these will be not here as an PIL. Okay. The Supreme Court evolved the following principles. Now we are going to talk about the principles of PIL. Okay. The Supreme Court evolved the following principles in regard to the PIL. The first principle is that the court in exercise of powers under the Article 32 and the Article 226, like we had discussed, Article 32 gives the power that person could move to Supreme Court in case of violation of human rights, and Article 226 person could move to the High Court in case of violation of human rights. Okay. So 32 stands for the Supreme Court and 226 for the High Court. Okay, can entertain a petition filed by any interested person in the welfare of the people who are in disadvantaged position and thus not in a position to knock the doors of the court by themselves. The court is constitutionally bound to protect the fundamental rights of such disadvantaged people and direct the state to fulfill its constitutional promises as under Article 32 and 226 provisions. Thereafter, when the issues of public importance, enforcement of the fundamental rights of the large number of people, vis-a-vis the constitutional duties and the functions of the states are raised, the court treat a letter or the telegram as a PIL. Okay. In such cases, the court relaxes the procedural laws and also the law relating to the pleadings. Like, in short, you can say the legally prescribed standards for filing the case will be relaxed in these cases. Whenever injustice is meted out to the large number of people, the court will not hesitate to step in to evoke the Article 14 and Article 21 of the Constitution of India as well as the international conventions of the human rights which provide for the reasonable and fair trial. So what do you mean by the Article 14 and 21? We will have the discussion over it during the fundamental rights. Okay. The common rule of locus standi is relaxed so as to enable the court to look into the grievances complained on behalf of the poor, deprived, illiterate, and disabled who cannot vindicate the legal wrong or the legal injury caused to them for violation of any constitutional or the legal rights by themselves. When the court is a prima facie satisfied about the violation of any constitutional right of a group of people belonging to the disadvantaged category, may not allow the state or the government from raising the question as to the maintainability of the petition. All right. Although procedural laws apply on PIL cases, the question as to whether the principle of res judicata or principles analogous thereto would apply depend on the nature of the petition and also facts and circumstances of the case. The dispute between the two varying groups purely in the realm of private law would not be allowed to be aggravated as a PIL. Why? Because the PIL only includes the cases of general or public or common interest. Thereafter, however, in an appropriate case, although the petitioner might have moved a court in his private interest and for redressal of the personal grievances, the court in furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. All right. Thereafter, the court in special situations may appoint the commission or other bodies for the purpose of investigating into the allegations and finding out the facts. May also direct the management of the public institution taken over by such commission. Thereafter, the court will not ordinarily transgress into the policy, shall also take utmost care not to transgress its jurisdiction while purposing to protect the rights of the people from being violated. The court would ordinarily not step out of the known areas of judicial review. High Court, although may pass an order for doing complete justice to the parties, does not have a power akin to Article 142 of the Constitution of India, which advises the President by the Supreme Court. Ordinarily, the High Court should not entertain a writ petition by way of PIL, questioning constitutionality or validity of a state or a statutory rule. That is only available for the Supreme Court. After this, now we have the guidelines for admitting the PIL. Like, what are the guidelines through which the PIL will be admitted? The first is, the PIL has now come to occupy an important field in the administration of law. should not be allowed to become the publicity interest litigation or political interest litigation or private interest litigation or paisa interest litigation or middle class interest litigation. It means that the PIL must be for the common, public or general interest, not for some publicity, not for some politics, not for some private matter, not for some paisa or the money, and not for some middle class interest litigations. Here's why. The Supreme Court in this contents observed PIL is not a plea or a panacea for all wrongs. It means that not all cases could be plead to the court under the PIL. It was essentially meant to protect the basic human rights of the weak and the disadvantaged who could not represent themselves to the court by themselves. Was a procedure which was innovated where a public spirited person file a petition in fact on behalf of such persons who on account of the poverty, helplessness, economic and the social disability could not approach the court for relief. There have been in recent time increasing the interest of abuse of PIL. Therefore, there is a need to re-emphasize the parameters within which PIL can be resorted to by a petitioner and entertained by the court. Okay. Therefore, the Supreme Court laid down the following guidelines for checking the misuse of the PIL so the PIL misuse could be prevented. And what are these guidelines? Let's have a look on it. The first is the court must encourage the genuine and the bona fide PIL and effectively discourage the curb the PIL field for extraneous consideration. It means that there must be some prescribed standard for filing the PIL and must be some prescribed conditions. Instead of every individual judge devising his own procedure for dealing with PIL, would be appropriate for each High Court to properly formulate rules for encouraging the genuine PIL filed and discouraging PIL filed with oblique motives. It means that it is not should be based on the discretionary of the judge whether he should accept it as a PIL or not, but there must be some common procedure so that all the judges will require to follow the same thing. The court should prima facie verify the credential of the petitioner before entertaining the PIL. It means that on the matters on which the PIL was filed, this must be genuine, because if they are not genuine, the court will waste its time. The court shall be prima facie satisfied regarding the correctness of the contents of petition before entertaining the PIL. It means that it is responsibility of the court to verify that whether details which have been mentioned in the PIL is correct or not. The court should be fully satisfied that the substantial public interest is involved before entertaining the petition. Then only the court will allow to entertain the petition. The court should ensure that the petition which involves the larger public interest, gravity and urgency must be given priority over other petitions. Okay. The court before entertaining the PIL must ensure that the PIL is aimed at redressal of genuine public harm and public injury, but not based on the private interest. Court should also ensure that there is no personal gain, private motive or oblique motive behind filing PIL, as we had discussed. Thereafter, the court should also ensure that the petition filed by busybodies for extraneous and ulterior motives must be discouraged by imposing the exemplary cost or adopting similar novel methods to curb frivolous petitions and the petitions filed for extraneous consideration. Okay. So students, basically in this lecture, we have done with the PIL. Okay. We have finished the given topic of the PIL. I hope that the topic was understandable for you. Okay. In the next lecture, we are going to start with another important topic. Till then, it's my request to you all, kindly revise the facts and figures whatsoever we have discussed in this lecture in the well enough manner before you come for the next lecture. As many times I have reminded you, that's for your own benefit. With this note, let's end this lecture and thank you.